Entertain a motion to approve them. Motion made by Mr. Rosselino. Is there a second? Second by Mr. Flynn. Any discussion? Hearing none, all in favor, say aye.
Aye.
Aye. Anyone opposed? That motion carries.
Right.
All right. A motion was made and seconded to accept the minutes as presented, and a unanimous vote was made on that. I'll let the record reflect the council members that are in attendance, as well as staff members that are here this evening. Next matter would be subcommittee reports,
There are no subcommittee reports tonight, Mr. Chair.
staff reports.
I have a couple items, Mr. Chair, to report on. One, as I mentioned a couple of meetings back about the green bond money that the CRMC has gotten to dredge the Providence River inside the hurricane barrier. And as part of that project, we were approached on removing the pilings that are on either the north and south side of the Point Street Bridge that are basically derelict pilings from back when Point Street was a railroad trestle. And the bridge actually rotated 90 degrees based on the navigation that needed to come up and down the river. Those pilings over the past 100+ years have deteriorated to the point of non-function. They're creosote, clearly an eyesore, but there's navigation and environmental hazards to that. So we were approached as we were dredging the river to also get rid of those. The issue that we found in not being able to attach that part of the project to the dredging project was a disposal site for creosote pilings, as well as the potential cost of removing them and disposing of them with the money that the green bond had left over in that account. Therefore, with the bipartisan infrastructure law that came out a couple of years ago, staff, and Bruce is here, he did it for CRMC, our staff, submitted basically an abstract, a pre-proposal underneath the funding source for the BIL portion of that funding to address marine debris. And we were successful in that pre-proposal and have been asked to submit a full proposal in hopes that we are successful to get the money to remove the entirety of those creosote pilings, both north and south of Point Street Bridge, with a disposal site for those types of pilings. So we're very happy about that. Thank you to Bruce for taking that on for us and moving it forward. And again, we hope to be successful in the full competition. The other, just three quick matters. You all are aware of our tool called Storm Tools that we've developed with the University of Rhode Island that looks at flooding issues, coastal erosion, storm events, and what it does to our shoreline, and predicts what the shoreline would look like under certain storm conditions over time and into the future. The developers of that, the university, primarily the civil engineering school, is looking to marry that same type of concept with inland flooding communities, especially the freshwater rivers of the state, and not only try to predict what the flooding of those riverine systems would be under certain storm conditions and whatnot, also to look at how coastal storms and inland flooding interact, as they often do, and they might tonight. So the university has gotten some funding to look at taking storm tools to the inland systems, the riverine systems, and applying those concepts there. CRMC and DEM are partners with the university in helping them get that project off the ground. That's just starting this semester. The Cohog Commission, we have our third or fourth meeting, maybe that's a meeting next week. And one thing that staff would like to do starting this spring is bring back fairly regular coastal education series presentations in front of the council. As you know, last legislative session, the legislature passed the Shoreline Lateral Access Act, and we have been doing a lot to implement that as CRMC, DEM, and the Attorney General, but CRMC in particular has been pointed to as leading the implementation of that act. So we've done a lot, and we want to bring the council up to speed on what we've done and what we want to continue to do. Connected to that, we also were successful in using some of our competitive NOAA funds that we can apply for in any given year to look at a larger holistic shoreline access program. where we would like to present to you results of a survey of how people use rights of ways, how people expect to use rights of ways, some of the impediments for people to use those rights of ways, especially in environmental justice areas. So we'd like to make a couple of those presentations to you beginning as soon as the next meeting. So just want to let you know that that's coming. That's it, Mr. Chair.
Okay, any questions of Mr. Willis? Seeing none, okay. First matter on our agenda will be applications that have been out public notice and are before the full council for review and action. It's 2023-06-072, Brett and Judy Ciccchese.
Ciccchese, yeah, very good.
Right.
Brett Ciccchese, the owner and applicant, at Cove Street. And it is Jody. I talked to Lisa just to correct that.
Oh, Jody?
Yeah, Jody.
Okay,
And here with me tonight is Warren Hall, my dock engineer.
all right. So this is, you can come forward to the table. This is an application to construct and maintain a residential boating facility consisting of a 4-foot by 32-foot fixed timber pier, 4-foot by 18-foot ramp, and a 5-foot by 20-foot for 100 square feet terminal float. The facility is to extend 50 feet seaward of the cited mean low water mark per the submitted plans located at plat 87-4, lot 40 at 59 Cove Street, South Kingston, Rhode Island. And Amy has this for us to report, correct?
Yes. Thank you,
Okay.
Mr. Chair. Before I get started on the application summary, there are two corrections that I just want to make for the record. The first is on the first page of the bio staff report from Tracy Sylvia in the header. Staff recommendation says no technical objection, defer for objection. Should say defer for variances. That is an error. And also within the staff report in section B, on the second page of the bio staff report, there is in statement number 4, it says that the facility is proposed within 6 feet of the southern property line extension. The variance is 6 feet. It's actually 19 feet from the property line. So there's just a couple of housekeeping errors in that regard. The dock is located in South Kingstown on type 2 waters in an area called Cedar Cove in Potter Pond. This lot was one that was subdivided not too long ago, and in 2017, CRMC approved an assent to construct a house, septic system, buffer zone, standard stuff. The dock application was submitted, and during staff review, it was discovered that the buffer zone was not in conformance. So staff began working with the applicant to rectify that, and the plans were updated, and it all has been addressed within this dock application to staff's approval. The dock itself is proposed to be 50 feet beyond mean low water. It does meet the minimum 18-inch water depth standard. It appears to be roughly 2 feet at the terminus, give or take. As I noted by corrections, there is a variance to the side setback, section 1.3.1 D11K. The dock does not meet the north property line setback either, but did receive a sign off from that neighbor. So no variance is needed on that property line. There is also a variance to the nearby mooring field. There's a 26-foot variance to the 50-foot mooring field setback, which is section 1.3.1 D11M. Town of South Kingstown has signed off on their part of the harbor management and mooring field setback. However, both of these setbacks are ones which the council must decide. No comments were received during the public notice period. Staff has no objections to the application and only notes that prior to the issuance of the assent, should the council approve it, they will work with the applicant on the species of plantings to go within the buffer zone. Those are not finalized yet.
Okay, any questions
Just,
of maybe Mr. Gomez?
yeah, the variances that we're looking at, are they similar to others in that area that we've already looked at previously?
You did one recently in Potter Pond, just did the last meeting. I don't know exactly how close it is to this one, but
Yeah.
yeah, side setback variances. are really gone.
Going through the report, you seem to be okay with the variances asked, and I just wondering if, you know, they seem fine to me. I was just wondering if, you know, this was similar to others. I thought it was actually.
It is. Tracy was the one who did the review on this, but yes, side setback variances are pretty common with us.
Thank
And
you.
mooring field setback variances are pretty common.
Any further questions, Ms. Wall?
This may be a question, maybe more for legal counsel, but whoever can help. The abstention for the southern abutter, is abstention the same as no objection? Under our regs, so under the prerequisites, it says that they have to have a letter of no objection, so is
Under
abstention
the
the same?
regulations, when you are not meeting your 25-foot property line setback,
Mhm.
there's two pathways. You receive the letter of no objection from the neighbor, or you don't, and you request a variance.
So is abstention just, it's a
Get the letter.
non-relevant point?
Correct.
It
It's not an
equals-
objection. It doesn't, sometimes people can't find the neighbors because they live out of state and they just simply can't track them
So
down.
it is the reason why there's a variance request.
Correct.
It is
They
the
do not
only
have-
reason why there's a variance request.
Correct. If that neighbor if they had been able to contact them or had been able to get it for whatever the reason is, they didn't get it. If they had gotten it, there would not be a variance for the side setback.
And is there any prohibition about processing an application when there's a enforcement or a lack of compliance on the site from a previous assent that's unresolved?
The issuance of this will resolve it.
Building a dock will resolve the plantings?
The plans have been updated and they show the correct buffer zone with the buffer zone markers and the plantings.
Okay, so there's no restriction to processing an assent when there's non-compliance or processing another request for a permit when there's non-compliance from a previous permit.
There is when it is not resolved within the application before us. So we have a standard practice that if a property is in non-compliance,
You don't process.
we don't issue anything else. Frequently, the applicants work with us with whatever is in front of us, and we are able to rectify the issue in that process or with a separate application. They sort of go hand in hand.
Because the plans for a dock would not usually deal with a vegetative buffer for construction of a.
They're supposed to depict it, though.
Right.
When an application comes in, it is supposed to depict any and all.
Existing conditions,
Correct, and it didn't. When it first came in, it didn't show it. So.
because it was out of compliance.
Correct, it wasn't there, it had been moved. So Tracy worked with Warren and the applicant.
So you can process an assent with a violation if the applicant is willing to correct the previous violation. So
This didn't even go to enforcement.
right,
There's no
but
violation.
non-compliance, let's call it.
Correct. Yeah, when we resolve it through that assent, it gets all tied up in one.
Got it. Thanks. Mr. Chair.
Yes, Ms. Reynolds.
I may have a question about in the staff report under staff comments. Number 3 says the staff has received complaints regarding neighbor conflicts in the past and during review of this facility. In your presentation, you talked about there were no concerns presented or things that were unresolved. Could you just talk a little bit about what those complaints were?
It is my understanding that the complaint was that this property owner was mowing the southern lot. So it really wasn't fully related to the presence or absence of the dock.
Because it's odd, it's then followed by the, speaking about the plans now show a planting buffer. So that's gonna resolve that issue with mowing.
Hopefully it should, because
Okay.
the buffer would then be marked, the buffer would not be mown, and then wherever the mowing was going over the property line onto the neighbor's property should cease.
Wasn't the buffer marked when they got the permit to begin with?
It was supposed to be, but it does not appear that that occurred. When they got their house,
Yeah.
that is a standard stipulation that the buffer be marked and the buffer be allowed to grow. And it does not appear to have occurred here. That happens a lot.
Further questions?
Just one.
Yes, Mr. Flynn.
Chairman. So the shape of this lot, it's what we'd call a hockey stick lot. But on either side of it, it looks like it's mowed right down to the water. So there's nothing that's gonna change that. Right? You can only deal with the little skinny
Correct,
bit in red that's in front of you.
correct. If the lot to the south were ever to be developed, it would also receive a buffer zone. It is currently undeveloped. If and when that,
So who's mowing it?
I don't know exactly. There was a
Like, who
complaint.
would bother mowing a lot that they don't live on?
If I may, the landscaper is, oh, Chancellor, get this.
Sure, why don't you, have, Attorney Hartman swear you in so that any statement you make will be, appropriate before the council.
Sir, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Would you please state and spell your name for the record?
My name is BRETT JUDICICCHESE, BRETT. Last name CICCHESE.
Thank you, sir.
I just want to provide some clarification.
Sure.
because it seems so. The question was about the southern lot, which was the same family that owns the southern lot as that I purchased my lot from. The landscaper and the owner of that lot had an arrangement that he would mow the lot. The owner was handicapped. He thought he was doing a good thing. I didn't pay him to do it. He did it on his own, arranged through with the owner. The wife sent us a letter and said, please stop mowing that lot. It was directed to me, misdirected. I told the landscaper, give her a call to resolve that. She didn't want him mowing that lot anymore, so now it's not mowed. And the owner takes care of that property, and the landscaper's not doing it. That's where that resides. I was mowing my property, maintaining it, which I should not have been. We submitted the dock application that highlighted the fact that they need to be in compliance with the 150-foot buffer zone, and I stopped mowing it. And we worked with Tracy to come up with a buffer zone adjustment that suited this hockey stick lot, if you will. So once we get through the buffer zone, the plantings, that grass that is in that hockey will stay unmowed.
You'll have less to mow.
Correct. I hope that answers both kind of questions.
Shit, that thanks.
Any further questions at this point
I have
of the
just-
applicant, Ms. Reynolds?
Just,
or any
I just,
council?
one comment on the plan that we have in the record, it says there's a draft stamped on that. That's supposed to be removed. So, SK-12-15-23 buffer zone restoration. On the lot in question, it says draft.
It looks like the questions can be directed to Mr. Hall. And Mr. Hall, just for the record, if you can identify yourself, please. This way, now. And we'll have you be sworn as well.
Mr. Hall, thank you for raising your right hand. Would you please, would you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Would you please state and spell your name for the record?
Warren Hall, WARRENHALL.
Thank you.
So.
Just a quick, it just looks like the notation must have been left on, or is this still just a draft?
That's what I'm thinking, that it was left on because we went back and forth a number of times with drafts and then finally finalized it. but I don't see,
It's on the lot itself, right underneath the structure. Says draft.
wherever. Cycle. So that's the plan, SK 1215-23. We'll have draft on the lot itself. We'll have to remove that draft note. If that's,
Okay, I'll take the plans down.
we can do
I
that.
would ask to clarify. Hey, Warren, you had sent a letter on behalf of your client dated December 18, 2023, that attaches the plan we're looking at. But the way I read that this is submitted on behalf of the applicant, please find 2 copies of the enclosed buffer zone management plan, regardless of the word draft, which maybe shouldn't be there, what we're looking at is the buffer zone plan that was worked out with staff.
Yes.
Okay.
Yeah. With some changes, notations, eventually, we're going to agree on the vegetation,
The actual plants,
the plants.
correct. Okay. Thank you.
Any questions by the council of the applicant or his expert, Mr. Hall? Is there anything either of you would like to add to what's been presented by way of the record, as well as statements made this evening?
I don't have anything to add. I mean, you know,
All right.
So we vote on the variances first and then the application second. Is that the normal procedure?
No, you could include it.
That's included.
Wraps in the variances. Generally, when we're voting on special exceptions, that would be a separate vote, but variances is the same vote.
Okay, sure, exceptions. Okay, second.
Is the council ready to make a motion?
I'll make a motion that, based on the findings of fact, the staff report, which was again an excellent job, and the nature of the variances, which don't seemingly support a precedent, as there have been similar variances granted before, and based on the lack of objections and no objection from the town, I would move approval.
And Mr. Gomez, this is also kind of a question to Ian. Does that include the staff stipulation on?
Yes, in fact, I was going to question what that stipulation was, but it would be including the standard stipulation as stated. I guess I don't know what standard is. So. Okay, the planning, okay, it's on the, how about that? It's on the front page, the staff stipulations are planting markers, installation time frame, and staff annotation of buffer zone restoration plantings as discussed with the applicant. That would be the stipulation.
All right, a motion has been made. Is there a second?
Second.
Seconded by Mr. Izzy. Any discussion? I'll poll the council. Mr. Flynn.
Aye.
Mr. Izzy.
Aye.
Mr. Gomez.
Aye.
Mr. Russolino.
Aye.
Ms. Hall.
Aye.
Mr. Gagnon.
Aye.
Ms. Reynolds.
Aye.
I too, Raymond Coyer, vote aye. The application has been approved unanimously. You're all set. Congrats.
Thank you very much.
Be careful traveling back. Next on the agenda is proposed rulemaking before the council for review and action. Management procedures 650-RICR 10-00-1 to amend sections 1.1.4.15 to reference the administrative penalty matrix guidance for violations of the Rhode Island Coastal Resources Management Program within the state of Rhode Island. Who will do this?
Mr. Chair, Bruce Lofgren, our coastal policy analyst, has this, and just as a reminder, we had the public hearing for this a while back during the public comment period as per state regulations. So the only thing in front of the council now is a discussion and hopeful positive approval on the passage of this. Bruce can give you the travel from then till now.
Thank you, Mr. Chair. Yeah, so just a little background history on this. The administrative penalty matrix has been before the planning and procedures subcommittee twice now. Originally, it was at the end of 2022. And at that time, the planning procedures subcommittee recommended that we do propose it for rulemaking, but when we submitted it to OMB, they preferred that it be incorporated into a regulation. At the time, we were proposing it as a guidance document. So we came back to the planning procedure subcommittee at the end of last year, with it now incorporated into the two regulations into the regular and the administrative procedure. At the meeting, the planning and procedures subcommittee unanimously recommended that staff initiate rulemaking. We published the public hearing at the end of last year as well. It was a 30-day public notice period. We held a public hearing here. We did not receive any comments. We did receive one written comment or questions from Safe Bay, which staff addressed, and there were no further questions or comments after that. And other than that, we did not receive any public comment on this. Happy to go over the matrix if the council would like.
What's the council's pleasure? Any questions of Bruce? I know it's been here before, but Ms. Hall?
Thank you for the packet and all the information. And I know we had this in front of us, but this is our chance to get further clarification. I read that your purpose is for fair and transparent assessment of how the agency assesses penalties. And I would imagine the purpose of that is not just furtherance of due process and transparency, but also that they stick on appeal, right? So that the hearing so the executive director assesses it and any appeals of that stick. And I'm concerned about the fact that there's some definitions that I think would be useful for that transparency. And maybe just for lack of familiarity with the whole process that perhaps you can help. I'm curious about how deviation from the standard is defined. In other words, what factors specifically would be considered in deviation from the standard? So for example, leave aside special circumstances because that's different, and you provide examples of when special circumstances would go up and special circumstances would go down. But this, within my understanding of how you'd use the matrix, the extent of deviation from the standard is really significant. And that's going to make a big difference. And is it deviation from the standard is, to me, because it's so important, having it be undefined or not even having like a list of factors, because deviation from the standard is really hard to define. But if you had a list of factors that would be considered as warranting how great that deviation was, it seems like that would lend to the transparency. So I was wondering if you could educate me about that.
Sure, I can try. So when you're talking about deviation from the standard, are you looking at,
Or deviation from the regs, it says,
From the regs.
extent of deviation from the regs.
all right, so you're looking at C1, the table.
Yeah.
So for extent of deviation from the regs, so this is under, the general I guess identifier of impacts to public health, safety, welfare, and the environment. And I think I mean, enforcement staff is going to be the one applying these, and originally they were guidance documents, but now they are regulations. So I think it's, I guess, the extent of the activity, the violation, and how far that deviated from the applicable standards for that violation.
Well, when you say extent, you don't mean aerial extent, right? Because that's the box to the left. Or is area affected simply the type of waters? And then maybe extent of deviation is aerial extent, or like the nature of the act, or the duration of the act, or I don't know. I'm just wondering.
I could, if you don't mind, I'll jump in on this. So to get some perspective on where the matrix is derived from, was initially intended as a guidance document to interpret the regulation that's provided. Let's see, 650 Rick Road 20 tact 00 tact 1. 1.1.30.
It's this whole packet.
Exactly.
Yeah.
So it's in the matrix, from my understanding, was intended to provide light to that regulation. So the extent of deviation of regs, if you look at C1 and C2 of that initial regulation that's actually still in force, it talks about the actual or potential impact on public health, safety, and welfare and the environment of the failure to comply. That's number one. And then C2 is the actual potential damages suffered or actual or potential costs incurred by the council or by any other person. So,
Right, but that's box 3. We already have that in box 3.
and I think those things are tied together.
So maybe one box here instead of 2?
That's not.
Because that would be a concern of a reviewer, right, of fact, and in terms of like thinking about appeals, what factors were considered, because that's, like if I get assessed a penalty and I don't like it, I'm gonna go after that standard. And I'm gonna want to know what the factors were. And there's a section in here where they add little notes, but like you'd want to say, oh, these factors are the ones you looked at. Well, let me show you evidence on those factors where it's not as great as you thought. But I don't know what those factors are.
So if I may, the enforcement staff's gonna have a report behind all this. And like Mark was mentioning, C1, 2, and et cetera through 11,
Yeah.
the report will be addressing that. And from that report, which is a narrative, should be able to transfer out into this table. So that should be the basis for coming to a tabular format, if you will. We'll have the staff's enforcement report behind that, backing it up.
So which of these things 1 through 11 would fit into this box here in the middle? Because it's not 1 and 2, because that's the box on the right.
Well, so I think
So
that's,
C1 through 11 are the factors. Which ones fit for this one? Extent of deviation from the standard.
I think that C1 fits the middle box and C2 fits that third box. So C2 is talking about the actual potential damages and costs incurred. Whereas number 1 is talking about actual potential impact on public health.
Okay. So can I ask another question then along that line? If you go to a violation that perhaps, for example, isn't number 1 and isn't number 2, I don't know, it doesn't impact public health and safety or welfare necessarily. For example, failure to post your assent card is a violation. You get a fine. Do you get a fine with that? If you don't post? You know how you have to post your accent card under our rules?
If
Do you
that's,
get a
the-
fine?
if that's the only thing you're doing, I think we would issue a notice of violation, not
And you
necessarily
wouldn't get
a
a fine.
fine.
So this matrix won't count those.
Possibly, but if it's one of many, it could be
So
in aggregate.
where would that go? Is that like under extent of deviation or is that public? Like, where does that go?
It would make sense to go under extent if you had to pick one.
And I don't know if that's covered under C1 through 11. Is it covered under there?
I'm sorry, what's that?
Is that type of thing, is that type of scenario where they're not transparent about the fact that they have a permit? Or, you know, is that covered under these definitions or this sort of rubric?
Yes, because if you look at the mitigating and aggravating factors, it talks about intentionality. And that's also reflected in the current enforced regulation.
So
Do they,
So where's the score gonna go for that? What box is that gonna go in?
if you look at C2, the third box from the left. And it's also reflected in, so it gets confusing because both of them are. under
Yeah, I'm just looking at the
C.
baseline penalty. Where's the number on?
Well,
for-
so that actually
that.
goes to aggravating.
Down here somewhere?
And mitigating factors, aggravating. And then, so under C2, we have aggravating factors, permit/enforcement history, public interest and intentionality. That's something that they knew about it, but they did it anyways. And that's also reflected in the enforced reg under C8.
So is there a way to provide definitions for these?
Well, I think that
categories?
definition is provided in C8 of the enforced reg, which says whether the failure to comply was intentional, willful, or knowing, not the result of error.
It's a comment. This has been through planning and procedures. A lot of this has been discussed, I guess, several times. What we're looking at is fairly close to what went through the planning and procedures.
Yeah, there have been no changes since, the last one.
So there was substantial discussion that brought us to this point. And what we're looking at is is this kind of a living document that if you put it in place and it downstream, you find that there's a section that's not working appropriately, it comes back for a revision, I would expect. Is that not true?
In implementing this, if we find
So
that
what I'm looking at is a very good, we need to get this done. It's a very good, it's more than a start. It's based on a lot of previous discussion. And I think that over a period of time, as you use this, you decide whether you need to adapt something a little differently or not. I'd be in favor of, based on the planning and procedures discussion and previous discussions, it looks really good to me. If you go in and you try to pick a point, you can always go in and pick a point and look at this word, look at that word, what's the word mean, et cetera, et cetera. But I think this goes a long way to do what we council, with staff and council together and worked on for a while. More or less, I'm pretty much in favor of it the way it is. And if there's a serious problem, which we don't really anticipate, but if something pops up with data coming in or complaints coming in, then we'll address it at that time. That would be my opinion.
Yes, Ms. Wall?
Have you had a case in Superior Court on your administrative penalties and your assessments with this report type procedure with, I know this was a guidance document, but has this been tested in Superior Court and have your penalties, has it been upheld in terms of the adequacy of the evidence and the adequacy of the due process notice to the
So,
complainant as to how the fine was assessed? Because that would be really informative.
absolutely. So I'll have a two-part answer to that question. I'm gonna defer to staff on that one because I haven't had the experience with the agency long enough to see one of those cases come up to Superior Court, and maybe Jeff will be able to provide some insight. But there's a second point, which is I have researched how other agencies, how they fare through an appeal of a fine or a sanction. And they fare well because it's a very high standard to overturn it. The court applies an abuse of discretion standard, or in other words,
I know what arbitrary and capricious, and I understand that, but I think part of the reason they are upheld is because they're defined. Like they define things like indirectly impacting public health, safety, and welfare versus directly impacting public health, safety, and welfare. We don't have that. It defines the factors as to what constitutes a deviation from the standard. We don't have that. So I think in those situations, those agencies have those definitions. And that might be part of why they are upheld as not arbitrary or capricious, because they have put the public on notice as to how the penalties are assessed.
I would have to go through a specific case by case to make that determination. And I hear you, and I take the word, but I'll just add this. This is the cases, they kind of use different language when they're making determinations on these sanctions. One is arbitrary and capricious. Ones they provide an abuse of discretion standard. Basically, did the agency do something that's completely unreasonable? And then the other that they talk about is they provide deference. They defer to the agency on this. And depending on which court you ask, deference can be different. But generally speaking, they defer to the agency on the appropriateness of sanctions.
Thanks.
Any further questions?
I'd just make a comment. I think
Yes.
what Ms. Hall was saying, and she needs me to interpret her comments, but there is a certain level of subjectivity that's going to go into who points are being assigned. I mean, I don't know if there's any way around that completely. It actually might be interesting, and I'm not suggesting delaying this, but it might be interesting if we sort of did a test run on some recent enforcement cases that we've had just to see where they would end up on this matrix. Like say what we had last month with the Sheffield issue. How would that have scored on if we were using this sort of a matrix on that case or other cases? And I have a question. So the person who fills this out is one of the few enforcement officers that we have, correct? We have what, 2?
Correct.
Has any thought been given on something that would generate, let's say, a high level of points from a reviewer, that a second reviewer might take a look at that also, just to confirm that the initial reviewer may not have been too harsh? Would that be something that could be done?
Procedurally, anything can be done. What we envision is the enforcement staff coming to the executive, Laura, or myself, with their report, with their matrix filled out, their points rationalized, and saying this is what we think should happen. And Laura and I have to sign off on that. So if at that point we have issues with it, we'll go back and go over it with them for sure. But having a second set of eyes is always going to be a good thing.
And when they fill out this matrix, you mentioned that it's also accompanied with reasons why that point level was assigned to that particular item, correct?
Yes.
Yes, Laura.
I'd just like to point out that enforcement staff has been using this matrix as a trial since our last public hearing. And none of the fines yet have been challenged based on the matrix.
Oh, so fines have already been assessed?
Yeah, every fine that's been issued for the last few months has one of
been-
these
has been
forms
using
filled
this.
out and it's part of the file.
Mr. Chair.
Yes, Ms. Reynolds.
So I understand that we've looked at this and this has been something that's been around for a while. But in the interim, the state has done a lot of work on zoning legislation. And one of the things that they eliminated was this financial consideration as part of the standards. So now when I look at this, number 7 and C looks very out of place with the rest of them. The amount necessary to eliminate the economic advantage of non-compliance, including but not limited to the financial advantage acquired of the competitors. And with zoning, for that we deal with, those kinds of things have been eliminated by the state. And it doesn't seem to really fall into the same sort of categories as the rest of them. Is that something that's been held over from something before, or is that something?
If I can answer, that's
Yeah.
right. From the initial drafts to today, this has been in there. So your point's well taken that since the initial drafts, legislation has come forward that where this particular C7 might not be applicable anymore. And if that's something the council would like to remove, we can definitely remove that tonight.
And Mr. Willis, could I also address that?
Mm.
The intent behind that falls in a lot of these environmental enforcement actions. If you look at DEM, EPA, it's really a consideration of whether the enforcement action is a permit to pollute per se. Is this something where we're going to assess a penalty that's so light that the person that's subject to the enforcement action is going to say, I'll pay the fine, just let me do what I want to do. So I think it's slightly different than the zoning context about zoning relief, because this is really focused on, this is kind of an environmental thing that comes out of the EPA, DEM world.
I would just add that is not going away at all in federal environmental regulations. Like that is a really critical part of EPA enforcement, particularly in the water cases, and we are at the water. So I would not want to see that disappear, and I would not want to see the agency not use it. That is exactly spot on why it's being advocated still pretty strongly at EPA.
Okay. Any further discussion? Mr. Rossellino?
So would there be an appeal process of some sort if the enforcement action that you blessed was objected to, would they come before the full council or go before a court, or is there no appeal process beyond that?
Any decision of the council is appealable, but in this particular case, it'd be appealable to our hearing officer. The fine would be.
That was a red line in the document, and you struck out hearing officer, replaced it with chairperson, executive director.
Right, because initially, these actions are coming from the staff through the executive director to making a decision on whether or not a fine should be levied against a violator. The hearing officer would be if it was appealed, it would then go to the hearing officer. So in terms of process, it needed to come through the executive first.
That's right, and so.
That's why we struck out hearing
It's
officer.
okay to remove the hearing officer, and, I just, what you're saying, I guess, is on the appeal process, the hearing officer would come into play.
Correct.
Fine.
Right, Nick, further, just as a,
Are we under any time constraints to pass this regulation? Or can we continue to discuss it for another point?
The council can do what it pleases. I'd answer, there's no real time constraint, although we have been looking at making these changes for quite some time. As Bruce mentioned in his opening, we started this in 2022. We've been working with our federal partner to address how we can better address violations of the program through a more transparent and open process. So as part of our federal review, this was one of the actions that they'd like to see happen. And on the advocacy side, Save the Bay has been asking for this for quite some time. So no, there's no direct time frame of which to get this done, but it's sooner than later.
Okay, yeah, fair enough. And I don't think anybody's talking about reinventing the wheel, but when I read through it, I was also concerned about kind of the lack of definition for some of the criteria that the enforcement officers and the other staff would be looking at to levy the fines. And like area affected, is that gross area or is it a percentage of the lot that's involved? Or
I think.
Yes, the answer is yes, because it could be the buffer zone that's affected, or it could be the coastal feature that's affected, or it could be an upland part of the lot.
Right. I think a lot of these types of procedures, you need to build in a little bit of wiggle room in it so that you can make a subjective, more subjective assessment as opposed to having, very strict by the number, if it falls here, yes, if not, no. But I see it more or less as I discussed before, as kind of a living document. If it doesn't work, we'll fix it. I think we need to get it going. I mean, it's just been so long that we brought this out and talked about it and had some briefings and meetings and things like that. I see that we've got a workable document. Let's put it to the real test. And I was happy to hear that, some of the previous things you've done over the last few weeks, you actually use this template to assess that. That's where we need to be. And my opinion still is that we should get this moved, approve it, and then wait and see. We can reassess it in a year. Pick a time frame if you want to do a reassessment. My opinion. So.
Well, I agree. I think we vetted it. Well, not I think. I know we vetted it at P&P, and we've had discussion relative to it. Staff has indicated they are using it. So to quote Don, it's a workable document, and maybe if we need to fine tune as we go along, we can. But I'd like to see something put in place to give it a little bit of formality at this point, but that's my opinion only.
If we're ready for a motion, I would so move approval of the document.
let me ask our esteemed legal counsel, is this a document that you anticipate would be sustained or upheld, looked on with approval by the Superior Court in case something got up? So based on your review of the case law, which I haven't looked at for a long time, but I can't remember many of the standards. So.
Thank you for slipping in case law there, because I'll just repeat what I said with Ms. Hall. I don't have enough just experience with the council to see cases come up and how they've been upheld. But with the case law, I think that the court provides significant deference to the agency's interpretation of its own enforcement procedures and how it applies the penalty. So I would anticipate that we could make a very strong argument to have this penalty matrix and the fines under it upheld.
And just to follow up on that, I know DEM has its own enforcement officers and procedures. And if you're on the receiving end of a fine, they can certainly seem arbitrary because they just say, you've been doing this for 74 days. It's against the rules and regulations in the fine steps. And I'm not sure if you've taken a look at the DEM rights or the OSHA rights, or, EPA rights. So and see how they fit in with kind of the paradigm that we're setting forth here.
So when the PNP subcommittee looked at it and the staff got together to create this matrix, it really was based in EPA and Coast Guard regulations. So that this is really much, it's a reflection of those regulations and their policies, but it's a reflection of those agencies' policies. And with the caveat that the EPA and Coast Guard standards are much more thorough, but that's because they're such a large agency. It's really, and they have enforcement over such a large swath of jurisdiction that it's going to be a hefty guidance document.
So first, I was the enforcement lawyer at DEM for over a decade, and trust me that they're not arbitrary. But yeah, I know they might. And the reason why they're not is because the OCI, Office of Compliance and Inspection penalty regulations are exceedingly detailed. Every term is defined, aerial extent, deviation from the standard, what factors are considered for indirect versus direct. There's no question at all. And I had to litigate those cases. And the reason we prevailed was because we had the definitions. DEM regulates wetlands. We regulate wetlands. Coast Guard has no bearing on this process at all, really, when it comes to land. So looking to those regulations is probably less helpful than maybe looking at OCI, Office of Compliance and Inspection regulations or DEM regulations. And so having litigated those cases and knowing what the Superior Court looks at, regardless of deference and all the rest, you can say we'll fix the regs, but the person on the receiving end doesn't want to hear about it. It's like, oh, I applied this reg that we don't love, but we were planning on fixing it. So don't worry. Well, you lose that case. You walk away from it. And I guess I think about it from a perspective of the work that the staff does. Why walk away when you don't have to? If they're doing the hard work of going through the notice of violation, why walk away? Because we think the regulation is half good. It's good enough. It's half good. And then they have to walk away and lose a case. That was the worst possible thing. Like, I hate that. And as someone who represented staff that worked their tails off, that's a sad story to go home to. Like, well, yeah, we had to walk away because we couldn't back it up with the definitions because they didn't know what. It felt arbitrary because we didn't have any notice as to what they'd be looking at. And that's what's behind my interest in protecting and preserving the work of the staff when they go out and they do these assessments. And that's the basis for, and that's, this fair and transparent process which is the purpose of the regs. Those words aren't enough. It actually has to be fair and transparent. So that's just from my perspective.
So I have a question because I'm hearing from two different people, so two different sides. There's some question on definitions. Are we able to identify what needs to be further defined? Because if we are, and there's a process that we can do that, to Stephen's point, let's continue it and have everyone be comfortable with it, if that's what the consensus is. So my question is, I guess, there's a document here, almost every word, being facetious, but almost every word could be open to interpretation, but are we able to identify in particular things that need to be, buttoned down as far as the definition? And if so, I guess I'll ask Jeff or Mark, what's the procedure that we do that and then bring it back in front of us? And what I mean by procedure is that, do we ask the council, let staff know, let Mark know, let Jeff know what words, phrases, or whatever we need further definition, and that's how we'll attack it? Or, like, what's the process?
Well, from what I've heard tonight, the process would be to look at section C in the management procedure, section C, which we've been talking about. What does area affected mean? What does extent of deviation from the regs mean? And and I'm focusing on those two because those are the two I heard the most. And the process would be, we could look at other jurisdictions up and down the coast that have fresh water, that have coastal jurisdictions, that have environmental jurisdictions, and we can see how their enforcement regs might be applicable from a definition standpoint to what we've been discussing tonight.
DEM
Bring
has them
that
all
back.
defined.
And other jurisdictions might be more applicable to a coastal program
But
than an inland program.
I wouldn't want to come back and then someone say, well, we didn't do this one or we didn't do that one. So, because you just mentioned a couple that we're talking about a lot.
Mhm.
So if there are other ones, how do we deal with that? Meaning, how do we draw attention to it? Do we say to the council, here's a document, review it, email you, staff, whatever, about anything that you think needs to be fine tuned, and then at least they're identifying areas of concern.
So go back to the process. We can bring all of these questions with our research back to a hearing. We can continue this hearing. We can bring everything back to the council, or the council can direct us to bring it back to P&P and we vet it out there.
And I'm only gonna say, like, we did that
Yeah.
last time, and P&P were somewhat satisfied, and that's why we're here. So if we do that again and then we come back and then the council's not fully satisfied, just my opinion, I'd rather bring it to the full council and let's deal with it and have everyone have an opportunity to say what they want, question what they want, and add what they want.
If this were, somebody didn't like the numbers that we arrived at with this process and wanted to go to Superior Court, I guess would go to the judgment, probably you wouldn't be throwing this thing out and just saying it's trash, start over. I would expect that a court would say, well, I don't think it's a $5,000 fine, maybe it's $1,000. They might just adjust some of the numbers, I would think, if you really thought that we overcharged somebody, I would expect that there would be a discussion on, it's not a discussion on whether you were right or wrong. You did something. It may not be worth a $10,000 fine, but it might be some lesser fine. And I would expect that's what would happen, as opposed to throwing it out and say, start over on a violation. So I still think you've got a very good ground truth working document that can grow. It's not wholly Bible, it's a working document. And I think the more data you can get on it, you can fine tune it downstream, and maybe we use it for a year and revisit if we had any problems and fine tune it at that point. That's still my take on it. And I understand the caution and let's go look again, but you can always say, look some more, perfect is the enemy of good enough, right? It is, that's a truism. So I'm not looking for perfect, I'm looking for good enough.
Yes.
Well, to get to the question, I guess you asked Mr. Coyer on, which I'm thinking if you just did the 6 categories there and defined each of them, that would, if you're going to do any definitions, you might as well do all 6 of them, even if some of them are easy to define, but maybe that should help resolve the issue.
And I would also add how you differentiate between violation that's directly related to public health, safety, and welfare, and how it's indirectly related and incidental, because that is also really important in the how you utilize this based on section C.
Anything else discussion wise?
Is intentionality also meant to include foreseeability? In other words, if they did X, they knew this would happen, therefore it's intentional. Is that considered part of intentional?
So
I guess that will come out if you define intentionality.
So it goes back to one of the initial points that I had made, which is that the matrix is tied closely to the existing reg. And
I
that,
think making those connections is going to be really important.
so that I was gonna ask, I had a question I was gonna follow up with, which is, so as far as intentionality, C8 in the existing reg talks about intentional, willful, knowing, and not the result of error. So
And not foreseeable. Doesn't mention foreseeability.
I think that,
Is foreseeability incorporated into knowing?
Maybe,
yeah, I think that
Maybe.
that ties into it.
but yeah, I think you're onto something.
So my question
This
for
is
you,
not a question of like, well, maybe C1 and maybe C2. It's clear.
so that's actually my precise question for you, which is, would it assuage your concerns if the matrix standards, let's say, are tied directly to the existing regs?
Yes, and if they were defined.
So does that mean that the existing reg should be further defined?
Well, these words that you're using, or maybe just change these words so that they're exactly in line with C1 through 11. Because I think that's the problem. The language in the matrix isn't the language here on every case. They're different. And that's what leads you to think, oh, well, then how do you define that?
So if it were the same, would that be acceptable?
It could be. I mean, you'd have to see what it looks like. I don't know.
I also think, having looked at it for a very long time, I'm not sure if I'm just going bug-eyed or not, but I think that on C2, there's a word missing. It should be the actual or potential damages, because it just says the potential damages, which looks like an oxymoron to me.
I think you're right on that, because further in that same sentence, it does say actual or potential.
And above it also.
All right, so
Do
what's
we
up?
want to, do we want to continue with, have some further discussion?
I think that's the
Down the
consensus.
street, whatever, 1, 2 months, pick something.
I won't pick a month or 2 months, because I would just say afford staff adequate time. So it seems that's the consensus. So if someone wants to make a motion to continue the matter, to allow staff to address the concerns brought to light this evening, at a timetable that they need, and then, the executive director can bring it back in front of us.
So moved.
Second.
All right, the motion was made by Mr. Gomez, seconded by Mr. Izzy. Any discussion? Hearing none, I'll poll the council. Mr. Flynn?
Aye.
Mr. Izzy?
Aye.
Mr. Gomez?
Aye.
Mr. Brusalino?
Aye.
Ms. Hall?
Aye.
Mr. Gagnon?
Aye.
Ms. Reynolds?
Aye.
I too vote aye. Having nothing else to come before the council, I'd entertain a motion to adjourn.
So move.
Is there a second? Motion made and seconded. All in favor, say aye. Aye. Anyone opposed? Meeting adjourned. Travel safe, be safe, good discussion.